A company secretly installed a program on an employee's work computer. It recorded every single key she pressed. Then a supervisor used what it captured to log into her personal bank account and read her private email. She sued for wiretapping. And she lost. Not because what happened to her wasn't real, but because of one technical detail in a 1986 law that still controls what your employer can legally do to you right now, on the computer sitting in front of you. Her name was Lisa Rene. In 2009, she worked at G.F. Fisher's, an Indiana company that installed something called a keylogger on her office computer, software that captures every character you type, the same way a security camera captures a room, except this camera lives inside your keyboard. Her employer wasn't only watching what she typed at work. The keylogger caught her personal passwords too, the ones for her bank account, her private email. Her supervisors used them. This isn't a 2009 relic. By 2026, roughly 7 in 10 American employees fall under some form of digital workplace surveillance, up from about 3 in 10 just 2 years earlier. That's the fastest expansion of workplace monitoring in U.S. history, and almost none of the employees under it know the legal rule that makes it possible. Here's the law that was supposed to protect her. The Electronic Communications Privacy Act. Congress passed it in 1986, back when digital communication mostly meant a fax machine. Makes it a federal crime to intercept someone's electronic communications without permission. But the law has 2 enormous holes built into it, and employers walk through both of them every day. The first is the business purpose exception. If a company can point to any legitimate reason for monitoring you, stopping data theft, tracking productivity, protecting trade secrets, courts have let almost anything qualify. The second is the consent exception. You already agreed to this. That login banner you clicked past on your first day, the line buried in the employee handbook stating you have no expectation of privacy on company systems, that's consent. You gave it the moment you clicked I agree without reading it. G.F. Fisher's had both, a business reason and a signed handbook. On paper, Lisa Rene's employer had done everything right. But Rene's lawyers weren't arguing about the handbook. They were arguing about one word in the statute: interception. For a wiretapping claim to work, the law requires proof that a company intercepted a communication. An intercept has a precise legal meaning. The acquisition has to happen at the exact same moment the information is being sent. Courts call this the contemporaneous interception requirement. Here's the problem for Rene. A keylogger doesn't work that way. It doesn't grab your password mid-transmission the way a wiretap grabs a phone call mid-ring. It sits quietly on the hard drive, saves everything you type into a file, and emails that file to an administrator later, sometimes minutes later, sometimes at the end of the day. Because of that delay, federal courts ruled the keylogger never actually intercepted anything. It just recorded. And recording under this specific statute is not the same crime as intercepting. The wiretapping claim collapsed. But that wasn't the only law on the table. Rene had a second claim, this one under the Stored Communications Act, a companion statute governing unauthorized access to data sitting on a server rather than data moving through the air. Here, the case went differently. The keylogger had captured Rene's password to her personal bank account and her personal email, accounts that had nothing to do with G.F. Fisher's. Her supervisors then used those stolen credentials to log in and read what was there. The court drew a sharp line. Capturing the password on a company computer? Legal, under the loophole we just covered. Using that password to break into a private account on someone else's server? That's a federal violation, full stop, no exception. That claim survived, so Lisa Rene technically won, but only for the second half of what happened to her. The keylogging itself, the thing that made everything else possible, was ruled completely legal. It gets stranger. Judges didn't stop at no intersection. They explained why, and the reasoning is where this stops being a technicality and starts looking like a loophole nobody built on purpose. The Wiretap Act only applies to communication systems affecting interstate commerce, roughly systems connected to the wider internet. Courts examined how a keylogger actually works at the hardware level. It captures the electrical signal from your keyboard before that signal ever reaches your network card, which means the instant your finger hits a key happens, legally speaking, in a different universe than the instant that keystroke reaches the internet. One court ruled that even if you're typing directly into an online banking password field, the keylogger caught you in the local universe. The one interstate commerce law doesn't reach. Somewhere, a federal judge spent real professional hours deciding that a keystroke isn't legally sent until it takes a scenic tour of your motherboard first. Congress regulated the phone call in 1986. Nobody thought to regulate the keyboard. So if the Rene loophole still stands, what actually stops an employer from watching you right now? In most of the country, almost nothing. Only a small handful of states require an employer to even tell you monitoring is happening. New York, Connecticut, Delaware, and starting this year, Maine, the first state to also ban surveillance in your home, on your personal device, or in your car. Everywhere else, silent monitoring is simply legal. No notice required. The stakes of that silence became impossible to ignore in 2025, when a hospital pharmacist in Maryland was federally charged after secretly installing keylogging software on roughly 400 hospital computers over 10 years, capturing login credentials from more than 80 coworkers and using them to access private accounts completely undetected. No alarms, no blocked installs, a decade of silence on hospital systems because nobody was watching the software that was supposed to be the only thing watching. The lawsuit against the hospital isn't about him. It's about the fact that nothing stopped him for 10 years. So what actually happened to Lisa Rene? Her wiretapping claim died. The keylogger itself, completely legal. But the Stored Communications Act claim survived. Her employer was liable, not for watching her type, but for what they did with what they saw. The ruling never changed the underlying rule. Courts still apply the same contemporaneous intersection logic today. That's not history. That's current law, right now, governing the device you might be reading this on. Here's the short version. Your employer can install a keylogger on a company device. In most states, they don't have to tell you. They don't need a special reason beyond business purpose. You already agreed to it. Buried in a handbook you click through. And under federal wiretap law, silently recording every key you press has been ruled again and again not even a crime. The only thing that's changed since 2011 is what happens next. If your employer uses your captured password to open your personal Gmail, your personal bank account, your personal anything, that crosses into the Stored Communications Act, and that part is illegal. Two different laws, two completely different outcomes, one keyboard. So what does this actually mean for you on your Monday morning at your actual desk? If you want a company-owned device, assume everything you type is logged, stored, and reviewable. Your passwords included, even the ones for accounts that have nothing to do with your job. That's not paranoia. That's the current legal baseline in the vast majority of US states. Practically, that means never typing a personal password, banking, email, medical portals, into a company machine. Even once, even quickly. The keylogger doesn't know the difference between your work login and your bank login. It just records the keys. If you're in New York, Connecticut, Delaware, or Maine, you're entitled to written notice that monitoring exists. Check your onboarding paperwork. It's probably already been disclosed to you in a document you never actually read. Everywhere else, ask HR directly whether monitoring software is installed. You're allowed to ask. They're not required to volunteer it. The technology got faster. The 1986 law didn't. So, did you know your employer could legally do this? Tell me in the comments, especially if you've ever actually seen a login banner like the one at GF Fisher's. If you found this unsettling, hit subscribe. This channel breaks down exactly this kind of hidden legal fine print every week. Next time, the clause buried in millions of American employment contracts that can let your employer legally claim ownership of the app, the book, or the business you build entirely on your own time. Most people who signed it have never read that far down the page.